Well, hello, everyone, and welcome to Uncivil Law, where we learn from the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are continuing our speed run of the U.S. Supreme Court. It is June, and that means that all the big decisions are dropping like it's hot. Because, I don't know, that's how the Supreme Court rolls. We have opinions announced today. We have opinions announced for tomorrow. And we have opinions maybe next week. So we will see. We have, I believe, if memory serves correctly, 13 cases waiting to be decided. So some number of those cases will probably be issued today. It could be one. I suppose it could be all 13. Maybe tomorrow's day of the announced opinions is just a head fake, which would be hilarious. We are just waiting for the Supreme Court to drop opinions at 10 a.m. Eastern, as is tradition. And we will go ahead and just share the window as we wait. There, yeah, that probably makes sense. Does this pay better? Yeah, this works for me. So this is SCOTUS blog, which is not a Supreme Court authorized thing. It's just a blog that exists about the Supreme Court, and they do the best work in terms of getting things out and releasing things. So we will see things as they are released and as they're announced from the SCOTUS blog. Your authoritative source, other than Uncivil Law, who's the most authoritative source. Your secondary source from Uncivil Law. So the secondary source other than Uncivil Law. So we are just, waiting. Good morning, everyone. Good morning to all you guys who are here. I don't know whether or not Law and Lawburn will join us. I sent out the invite to the entirety of LawTube, as it were, and we will see what we got. Good morning from Admiral. Good morning. Ghosty, Trish, No One, Rando, W, Mama 6, JR Callahan, Ona Wall, TX, Go, Charles LePage, Admiral Nelson, good morning. Mitova, David, Mr. Benecki, Barbara, Sherry, Secret McSquirrel. Good morning to everyone. 3 minutes to go. No, it's live streaming. That's no need to hit the refresh button. It's live streaming. As you can see, it's updating. We're doing fine. Sligador says, I'm a civics, government, political junkie. You're the only person doing this. Thank you. You're welcome. Thank you for dropping that Prime sub on Twitch. For those of you who have Amazon Prime, you can subscribe, which is a paid membership on Twitch. It's free on YouTube. On Twitch, it's paid. But it doesn't have to be your money. If you have Amazon Prime, you can subscribe for free because Jeff Bezos pays for it. So please do that. Good morning to everyone. Darth. Good morning, Pete. Vanessa. Lol Zoo Unicorn. It's Trenton. Hello, Trenton. Yes, I am Dave. Hello. Is Twitch the same name? Yes, it is the same name. It's just Uncivil Law. It's the exact same name. Twitch.tv/Uncivil Law. All one word, I believe, on Twitch. Remember, just for those of you who are not familiar with how this works procedurally, opinions are announced by the Supreme Court in reverse order of seniority. Whoever's been on the bench the least is where you start. Of course, the Chief Justice automatically has seniority because he's the Chief Justice. So you start with Justice Barrett. If you're going to start with Justice Barrett, you start with the most junior and you work your way up, which gives you a clue, or at least some head space, as to what opinions are going to drop and by whom. So if you don't see a Justice Barrett opinion first, you're not going to see one at all, basically, is the end conclusion you can draw from that. Thank you for the 100K. Congratulations. It is very, very appreciated, as always. It's 10. Yes, I appreciate everyone following following on twitch.tv/uncivil law. You can follow right there or subscribe. And Law and Lumber is here to join us. Law Daddy is here at the very last minute to join us. How are you doing, sir?
Did I make it on time?
You do. Yes, sir. Just on time. In fact, we have our first opinion dropping. Berger versus North Carolina NAACP, which I don't know anything about, but we're going to find out about together rapidly. Have I had my morning Guinness yet? I had my morning coffee. I had my morning Guinness. That's close enough. All right. It's 8-1 by Gorsuch. Okay. So that gives you some clue again, as always, about who might be releasing opinions and when, because Gorsuch, of course, is second most. No, is he most junior? No, Barrett is. So he's second most junior.
Second most junior.
All right. Okay. I got there eventually. I'll get there. All right. So let's see what we got. All right. All right. So this is writ assert. All right, fine. In 2018, North Carolina amended its constitution to provide for voters offering a person shall present photo ID. Ooh, photo ID case. Fun. To implement this mandate, the General Assembly approved a bill. The governor vetoed the bill. The General Assembly overrode the veto, and the law went into effect. The state conference of the NAACP then sued the governor and members of the State Board of Elections, a state agency whose members are both appointed and removable by the governor. The NAACP alleged the bill offends the federal constitution. I'm not sure how, but okay. The board was defended by the state's attorney general, who, like the governor, is independently elected, which is true in many states. In many states, in the U.S. system, incidentally, the attorney general is appointed by the president, but in many states, the state attorney general is an independent elected position. So the governor doesn't control them. Just an interesting little factoid there. Interestingly, continuing on. They alleges that the offends the federal constitution. The attorney general at that time was a former state senator who voted against an earlier ID law and filed a declaration in support of the legal challenge against it. The Speaker of the House of Representatives and President Pro Temp moved to intervene. All right, so what we've got here, it seems like, is we've got the executive branch refusing to defend a law that was passed by the voters. There was a constitutional amendment passed by the voters. The state legislature passed a bill to further it. The governor vetoed it. State legislature overrode the veto to pass it into law. The state attorney general is also opposed to the law and is going to refuse to defend it. So the state legislature wants to move to intervene rather than the executive. Okay, pretty interesting fact pattern. All right. The Speaker and House of Representatives moved to intervene, arguing that without participation, important state interests would not adequately be represented. The board's allegiance to the governor as tepid defense in parallel state court proceedings and attorney general's opposition to earlier things. They're not going to defend it, so can we? The district court applied the presumption. The legislative-led interest would be adequately represented by the governor, board, and the attorney general, and denied the motion to intervene. Unsatisfied with the board's defense following the denial of the motion, the legislature sought to lodge an amici briefing and accompanying materials, but the district court refused to consider them. Really? Refused to consider an amici? That's pretty dickish. Struck them from the record and granted a preliminary injunction barring enforcement. The Fourth Circuit considered both the district court's ruling in separate appeals before separate panels. Okay, so we got two different rulings by two different districts. We got two different Court of Appeals decisions, two for the price of one. That's great. All right, so we got a preliminary injunction and apparently something dealing with the amici brief being decided by two different panels of the Fourth Circuit. Fun. The Fourth Circuit considered these separately. On preliminary injunction ruling, the panel held the district court had abused discretion because the record contained insufficient evidence to show it violated the federal constitution. On the intervention ruling, a separate panel, agreed with the legislative-led legislatures and held the district court had erred when denying them leave to intervene. Eventually, however, the Fourth Circuit decided to rehear the matter en banc, so we got a third Fourth Circuit decision in the same case. Even more fun. Do you like Fourth Circuit decisions? I got your Fourth Circuit decisions inside your Fourth Circuit decisions. Eventually, however, the Fourth Circuit decided to rehear the matter en banc and ruled the legislative leaders were not entitled to intervene. This court agreed to hear the matter to resolve disagreements among the courts of appeal, or more properly, among the singular Court of Appeals, which has the rare position of being a split decision among the federal circuits when it's the only one on the proper treatment of the motion to intervene. All right. North Carolina legislators are entitled to intervene in this legislation. All right. So putting aside all the procedural complexities of the Fourth Circuit disagreeing with itself and leading to a circuit split amongst itself, the fundamental underlying question is the state legislature allowed to intervene in this thing? Or is it merely the Attorney General / Solicitor General of the state / governor who have authority? Are the state legislatures allowed to also intervene? Fine, let's decide that issue. That sounds fun. Okay, so the federal rules of civil procedure provide a court must permit anyone to intervene on timely motion who claims an interest relating to property or transaction that's the subject of the action and is so situated that disposing of the action may, as a practical matter, impair or impede the movement's ability to protect its interests, unless the parties adequately represent that interest. No one disputes the timeliness of the motion. The court thus addresses the two remaining requirements. States possess a legitimate interest in continuing enforcement of their own statutes, and states may organize themselves in a variety of ways. When a state chooses to allocate authority among different officials who do not answer to one another, as is the case here because independently elected attorney general, as I just mentioned, different interests and perspectives, all important to the administration of state government, may emerge. Appropriate respect for these realities suggests the federal court should rarely question that states' interests will be practically impaired or impeded if its duly authorized representatives are excluded from participating in federal legislation. Nor are states' interests the only interests at stake. Permitting the participation of lawfully authorized state agents promotes informed federal decision-making and avoids the risk of setting aside state laws based on incomplete understandings of relevant interests. The court's teachings on these scores have been many, recent, and clear. These precedents and principles are dispositive here. North Carolina's law explicitly provides that the speaker, so there's an explicit state law on point, which makes things a lot easier, right? Because if we had to decide this like from underlying constitutional principles, we'd be in a whole world of hurt. But we don't necessarily have to do that, thank God, because North Carolina has a statute on point that's going to save our ass. Hooray. These precedents and principles are dispositive. North Carolina law explicitly provides the Speaker of the House of Representatives and the President pro tempore of the Senate, as agents of the state by and through their council of choice, shall jointly have standing to intervene on behalf of the jointly assembled as party to any judicial proceeding challenging a North Carolina statute as part of the Constitution. Great. I'm sold. Great. End of analysis. I'm a happy camper. So I can solve this on a statutory matter, which as the Supreme Court makes me super happy camper. I don't have to decide like major issues of constitutional issues with separations of powers and blah, blah, blah. I can just be like, oh, great, statute. North Carolina can organize itself any way it wants. Fantastic. So they've organized themselves with a separate governor and a separate attorney general, and more notably to our purposes, also by statute, give the authority of the Speaker of the House and the President pro tem by and through their council the right to intervene in any proceeding challenging a provision in the North Carolina Constitution. Fantastic. I can decide this on statutory matters. Great. That makes my life easier. The state has made plain that it considers the leaders necessary party to suits like this one. The board submits that North Carolina law does not afford the legislative authority to represent state interests. Well, that's not what I'm reading, but the argument is difficult to square with the express language. See, if I can decide this on statutory matters, it's great. Alternatively, the board argues the statute authorizes legislative leaders to participate here violates the state constitution by usurping power vested in the executive branch alone. That power, however, is difficult to follow. Given the board's concession, the legislative leaders may intervene permissibly under the rule, and likely as a matter of right, if the attorney general ceases to defend the law. Yeah, I don't see any inherent problem with this. Like, where you draw lines between executive, legislative, and judicial authority isn't necessarily inherently problematic. Can you give, at least as a matter of state law, can you give executive authority to members of the legislature? Probably. Especially as limitedly as it is here as a motion to intervene to defend the legislature in a constitutional proceeding to which they have interest. I mean, sounds okay to me. Doesn't impermissibly blur the lines. The NAACP now offers a different reply, pointing out the rule permits intervention only by new parties and suggests the legislatures are already existing parties. That sounds like bullshit. This rests on presumptions that are formally and functionally mistaken. They've not only sued the state, they've not sued the state, but only certain state officers, and as far as the legislatures are not among them. Functionally, however, the suit implicates the sovereign interest regardless of the named parties. I mean, that all sounds pretty logical to me. Do you have any particular thoughts on this?
My curiosity when you started reading that, the second the logic made sense to me, I started to scan which justice disagreed with this logic. Do you want to guess before you scroll down and see it?
I already scrolled down and saw it. I'm sorry.
Oh, did you need to though?
Well, I mean, I always like to give benefit of the doubt. This is an 8-1 decision written by Justice Gorsuch, and surprising everyone, Judge Sotomayor is the sole judge in dissent on this opinion.
Yep.
I mean, if we had to decide this on constitutional grounds, then it could get complicated. But we don't have to, because North Carolina passed this statute. All it authorizes the state legislature to do is a motion to intervene to defend their interests if the attorney general doesn't want to.
Ooh,
so refresh. I'm good.
Refresh. Nancy
versus Ward. Another exciting opinion.
Oh my God, SCOTUS blog is so slow today. Do you know how many people must be on this freaking thing?
Some number of people. Let's take a look at Nancy versus Ward. Or Nance versus Ward, I apologize. And see what it has to teach us about the state of the law. Okay, this is on a writ of certiorari from the 11th Circuit Court of Appeals. A prisoner who challenges a state proposed method of execution under the 8th Amendment must identify a readily available alternative method that would significantly reduce the risk of pain. If the prisoner proposes a method already authorized under state law, the court has held this claim could go forward under 1983 rather than habeas. But the prisoner is not confined to proposing a method already authorized under state law. He may ask for a method used in other states. The question presented is whether a prisoner who does so may still proceed under 1983. Okay, so there's a statute. I don't know if this is statute by state law, but or federal law. But yeah, they have to propose an alternative method. And if it's authorized by state, great. If not, then how do you proceed? In the habeas, can you proceed by 1983? Or let's find out. Petitioner brought this suit under 1983 to enjoin the Georgia from using lethal injection. Lethal injection is the only method of execution Georgia now authorizes. Nance alleges that applying this method would create substantial risk of pain. As an alternative, Nance proposes death by firing squad, a method currently approved by 4 other states. The district court dismissed the 1983 suit as untimely. The 11th Circuit rejected it for different reasons. Nance should have advanced his method of execution claims by way of habeas rather than 1983. A habeas petition, the court has stated, is appropriate when a prisoner seeks to invalidate his death sentence. And the 11th Circuit thought that this was what Nance was doing. It's asserted that Georgia law, which again, the only authorized execution by lethal injection, has to be taken as fixed. Under that fixed law, the court said enjoining Georgia from executing by lethal injection would mean that he could not be executed as all. The court therefore reconstructed Nance's 1983 complaint as a habeas. So they reconstituted what he pled, which is always a little bit tenuous when courts do that, at best. Having done so, the court then dismissed it as second or successive because he previously sought habeas. That sounds bad. That sounds like bad pool. A person is responsible for bringing their own claims. They brought their own claims under one theory versus another. You should respect that choice. All right, 1983 remains an appropriate vehicle for a prisoner's method of execution claim, whereas here, the prisoner proposes an alternative method not authorized by the state statute. Both 1983 and the federal habeas statute enable a prisoner to complain of unconstitutional treatment at the hands of state officials. A prisoner may generally sue under 1983 unless his claim falls into a statute that implicitly it provides for exceptions to actions that lie within the core of habeas corpus. When a prisoner seeks for relief that would necessarily imply the invalidity of conviction or sentence, he comes within the core and must proceed as habeas. The court has twice held a prisoner could bring a method of execution claim under 1983. Although this case predates the court's requirement that prisoners identify alternative methods of execution, each prisoner has still enough leave to the court to convince the alternatives to challenge provisions were available. Because alternatives were available, the prisoner's challenges would not necessarily prevent them from carrying out executions, because in these other states, other methods were provided for. That made 1983 a appropriate vehicle. Not this method, the other method, fine. In Nelson and Hill, the court observed that using a different method required only a change in an agency's uncodified protocol. Here, Georgia would have to change its statute to carry out execution by firing squad. Except for that fact, the state would have, even more clearly than Nelson and Hill, been fit for 1983. Since of those cases, the court has required a prisoner bringing a method of execution claim to propose a way of carrying out the death sentence. Thus, in order to grant the method of relief, does not require necessarily the state be implementing the execution. Rather, the order gives the state a pathway forward. That remains true even whereas here the proposed alternative is one unauthorized by present state law. Nance's request for relief still places his execution in Georgia's control. If Georgia wants to carry out the death sentence, it can enact a legislation approving what the court has found to be fairly easy to implement method of execution. I mean, fair enough. Although that may take more time and effort than a changing agency protocol, which focus on whether a request for relief will be necessary to invalidate the death sentence. And anyway, Georgia has given no reason to think that passing new legislation would be a simple impediment, a substantial impediment. The Court of Appeals could reach a contrary conclusion only by wrongfully treating Georgia statute as immutable. In its view, granting Nance relief would necessarily imply the invalidity of his death sentence because Georgia law must be taken as fact. One of the main aims of 1983 is thus override and thus compel changes in state law. Indeed, courts not uncommonly entertain suits that may, if successful, require changes to state law. Under the contrary approach, the federal vehicle for bringing a federal method of execution claim would depend on the vagaries of state law. Consider how Nance's claim would fare in different states. In Georgia and any other state where lethal execution is the sole method of execution, he would have to bring his claim as a habeas. But in states authorizing other methods, where the court holds injunction lawful, he could bring 1983. It would be strange to read a statute. It would be strange to read state-by-state discrepancies in the court's understanding of how 1983, which is necessarily federal law, and the habeas apply to federal constitutional claims. That's especially so because the use of one vehicle could lead to different outcomes. And an inmate in one state could end up getting his request relief, while another case might have it thrown out. Okay. The approach the Court of Appeals raises one last problem. It threatens to undo the commitment the court made in Bucklew. The court has there told prisoners they could identify an alternative method not presently authorized by law. But under the approach of the Court of Appeals, a prisoner who presents an out-of-state alternative is relegated to habeas, and once there, it will almost inevitably comply with the second or successive bar. Okay, Kagan delivers the opinion in the court. Barrett files a dissenting opinion in which Thomas, Alito, and Gorsuch join. This is a 5-4 opinion. Interesting. What do you think, Rob?
I don't know. It's kind of tough. You can see why the split is the way it is. It's essentially accepting another vehicle to stay in execution, or at least provide a different alternative to the method of execution. I see the point. It's a way of getting to retroactive application without actually getting there. Bucklew came out and said, if you have an alternative method of execution, you provide it as an argument, you have that argument available to you. But if you've already filed for habeas at the time Bucklew came out, you don't have a vehicle to bring that up.
Mm-hmm.
1983 might give you that claim.
Mm-hmm.
I don't know.
My first thought is is there any constitutional problem with the solution being, okay, fine, we will send your ass over to wherever the shootings happen, so your execution won't actually happen in Georgia. We're going to send your ass over to Oklahoma or whatever, and because they already have the firing squad set up, and your execution can happen there. Is there anything that would prohibit that as the solution?
I mean, doesn't that get federal trial?
No. This isn't federal. This is purely state.
It's purely state law, but it's purely one state has prosecuted, convicted, and sentenced, right?
Mm-hmm.
And then
we're outsourcing the actual delivery of the judgment to a different state.
Ooh, that's tough, because the thing is, the judgment of that state is based on that state's own criterion and how they view penalties.
I mean, in this scenario, Georgia would presumably be doing it only to states that it found compatible for its purposes. So it would only be doing it in so much as they believe there was similarity or comedy between their laws. They'd only be outsourcing it to Oklahoma because they were cool with whatever Oklahoma had, and presumably Oklahoma is equally cool with this because they can't impose on Oklahoma. So if they reached an agreement, would that be okay legally?
I don't know, because then you have one state carrying out the execution for a crime that the other state convicted on. Like, you have one state as the executioner, the other state is the judge and jury. I can see a problem there.
Yeah.
Because you could essentially claim that the other state essentially murdered you because that state didn't hold you accountable for their laws, etc.
Well, I mean, there is. Well, here's a nice little twist for you. I mean, we do have the full faith and credit provision of the Constitution, and of course, a execution is an order from a court that
True.
says, so it's just honoring the judgment of a different court. So it's totally cool.
Interstate compact for executions.
Yes, interstate compact for constitution executions. That's right. That's right. Interstate compact for executions. That's right. We don't even need federal agreements on this. We'll just have mutuality of state agreements, and we'll just have forum shopping on where the execution is actually going to occur.
You want to see the fastest stay of enforcement ever?
And then one state, maybe Texas, will be like, "Hey, one stop shop. Come down to Texas. All the methods of execution. We got your lethal injection. We got your gas chamber. We got your hanging. No. We got your electric chair. We got your firing squad." One stop shop.
Is it Utah that still has the firing squad?
Randy's board of execution.
But Utah still has the firing squad, right?
I forget who did or not. Yeah. So yeah.
That's statutory mechanism, by the way, for the firing squad in Utah and how they play it out so that there's 4 blanks. What is it? 4 blanks, one round of live.
That's what my understanding is. Yes.
Randomized. Like, oh my gosh. Like if I ever get if that ever happens to me, if we create this interstate compact, I want to go out by firing squad.
Okay. My preferred method is nitrogen asphyxiation. I think it's the way to go.
Oh, okay. Wow.
Which is authorized in one state now.
10:21 a.m. We got dark real quick.
Well, that's the way the Supreme Court rolls sometimes. Okay, we got your next one, Vega versus Toccoa. Didn't we already decide this case? Whatever. We'll decide it again.
Ooh, interrogation. Okay.
Oh, is this the one? Okay, this is the one dealing with whether or not you can sue a police officer for violation of Miranda, which some people thought, that's why it sounds familiar, because I talked about it recently. And some people thought might overturn Miranda, depending on how deep the Supreme Court wanted to go. So has Miranda stopped being a thing? Let's find out.
Oh.
No spoilers.
I'm not.
The case arose out of interrogation of respondent, Terrence Toccoa, by petitioner, Los Angeles County Sheriff Vega. Deputy Vega questioned Toccoa at a medical center where Toccoa worked regarding the reported sexual assault of a patient. I remember this case. Okay. Vega did not inform Toccoa of his rights under Miranda. Toccoa eventually provided a written statement apologizing for inappropriate touching the patient. I remember this case. Yeah. The guy walks into like a CAT scan room or an MRI room, pulls the guy out, brings him into a side room to talk to him. There was a whole issue about whether it was custodial interrogation or not, but ultimately ruled that it was custodial interrogation, which, is somewhat questionable, actually, as I remember the underlying facts of the case, but whatever. Anyways, it was ruled to be custodial interrogation. It went to trial. The case was dismissed, and now we want to sue for violation of not reading us Miranda. Okay, fine. Toccoa was prosecuted for unlawful sexual penetration. His written statement was admitted against him. After a jury returned a verdict of not guilty, Toccoa sued for violation of 1983, seeking damages for alleged violation of constitutional rights. The Ninth Circuit held the use of the un-Mirandized statement against him in a criminal proceeding violates the Fifth Amendment and may support a 1983 cause of action. A violation of Miranda does not provide a basis for 1983. Okay. Section 1983 provides a cause of action against any person acting under color of state law who subjects a person to deprivation of any right, privilege, or immunity secured by a constitution. Toccoa argues that violation of Miranda constitutes a violation of the Fifth Amendment against compelled self-incrimination. This is wrong. In Miranda, the court concluded that the additional procedural protection were necessary to prevent violation of the Fifth Amendment right against self-incrimination when suspects were in custody or interrogated. Miranda opposes a set of What? I mean, this was what? I say what because I thought we decided this the other way like 2 years ago. That we decided that because there was a bit of an open question as to whether or not Miranda was constitutionally required or merely prophylactic. I thought we settled this the other way. Didn't we settle this the other way like recently?
I thought it was constitutionally required. Maybe he's going to go into it further.
Okay. All right. Imposed a set of prophylactic rules requiring the custodial interrogation be proceeding by now familiar warnings and disalign the use of those statements obtained in violation of the rules. Miranda did not hold the violation of the rules itself is necessarily constitute a Fifth Amendment violation. That's true. Miranda itself didn't. That makes sense, as unmirandized suspect in custody may make self-incriminating statements without any hint of compulsion. The Miranda Court stated that the Constitution did not self-require adherence to any particular solution for inherent compulsions of the interrogation process, as the decision in no way created a constitutional straitjacket. Since Miranda, the court has repeatedly described it as prophylactic. I thought they said exactly the opposite of that recently.
I'm speed reading.
After Miranda, the court engaged in a process of charting the dimensions of these new prophylactic rules, and doing so weighed the benefits and costs of any clarification of the rules. Some post-Miranda decisions found the balance of interest justified restrictions that would not have been possible if Miranda described the Fifth Amendment right, as opposed to a set of rules designed to protect that right. For example, in Harris, the court held the statement obtained in violation of Miranda could be used to impeach the testimony of that defendant, even though the involuntary statement obtained by the Fifth Amendment could not have been used this way. That's true. In Michigan, this court held that the fruits of an in-Mirandized statement can be omitted. So, yeah, derivative things, fruit of the prisoner's Troy. In doing so, the court distinguished police conduct that abrogates a person's constitutional privilege against compulsory self-incrimination from conduct that departs only from the prophylactic standards later laid down by this court to safeguard. Since similar in Oregon versus Estad, the court, following the reasoning of Tucker, refused to exclude a signed confession and emphasized the officer's error in administering the prophylactic Miranda procedures should not breed the same irredeemable consequences as police infringement of the Fifth Amendment itself. While many of the court's decisions imposed limits on Miranda's prophylactic rules, other decisions found the balance of interest called for expansion. For example, in Doyle, the court held that silence following Miranda cannot be used to impeach. The court acknowledged that Miranda warnings are prophylactic, but instead found that allowing the use of post-warning silence would undermine the warning's implicit promise that silence would not be used to convict. Likewise, in Withrow versus Williams, this court rejected attempts to restrict Miranda's application in collateral proceedings based on the reasoning of Stone versus Powell. Once again, acknowledging the prophylactic rules, the court balanced the competing interests and found the court's adopting of Stone-like rules outweighed any benefits. In sum, the court's post-Miranda cases acknowledged the prophylactic nature of the Miranda rule. I am so fucking confused right now.
Wait till you get to paragraph 3. You're fine.
The court's decision in Dickerson versus U.S. did not upset the firmly prior established understanding of Miranda as prophylactic. Dickerson involved a federal statute that effectively overruled Miranda by making the admissibility of statements given in custodial interrogation turn solely on whether it was made voluntary. The court held that Congress could not abrogate Miranda by statute because Miranda was a constitutional decision that adopted a constitutional rule. Yeah. Okay. Square it for me, U.S. Supreme Court. And the court noted these rules could not have been made applicable to states if they did not have that status. At the same time, the court made clear that it was not equating a violation of Miranda rules with outright Fifth Amendment violation.
Yeah, you're going to be frustrated.
Indeed, the Dickerson court described the Miranda rules as constitutionally based with constitutional underpinnings. These formulations obviously avoid saying Miranda is the same as violating the Fifth Amendment right. What? Miranda was a constitutional decision, adopted a constitutional rule in the sense the decision was based on the court's judgment about what's required to safeguard that right. I'm no more wise than I was when I started. And when the court adopted its constitutional prophylactic And when the court adopted a constitutional prophylactic rule of this nature, Dickerson concluded the rule had the status of a law of the United States that is binding on the states under the Supremacy Clause, and the rule cannot be altered by ordinary legislation. Dickerson thus asserted a bold and controversial claim. The court has the authority to create a constitutionally based prophylactic rule that binds both federal and state courts, but Dickerson cannot be understood any other way consistent with prior decisions. What? Subsequent cases confirm that Dickerson did not upend the court's understanding of Miranda as prophylactic. In sum, a violation of Miranda does not necessarily constitute a violation of the Constitution, even though they said like 5 sentences ago that it was constitutionally based with constitutional underpinnings, but a violation does not constitute violation of the Constitution. And therefore, such a violation does not constitute deprivation of rights. A 1983 claim may also be based on deprivation of any rights secured by law. But the argument that Miranda rules constitute federal law that provide ground cannot succeed unless Tekoh can persuade the court that the law should be expanded to include the right to sue for damages under 1983. A judicially created prophylactic rule should apply only where its benefits outweigh its costs. Here, where the benefits of permitting the assertion of Miranda claims under 1983 would be slight. Assumes facts not in evidence. The cost would be substantial. For example, allowing a claim like Tekoh's would disserve judicial economy by requiring a federal judge or jury to adjudicate a factual question, whether Tekoh was in custody when in question that already been decided by a state court. Well, if it's already decided, then res judicata. What are we talking about? Allowing 1983 suits based on Miranda claims could also present many procedural issues. Miranda and its progeny suffer procedural protection. Reversed and remanded. Alito delivers the opinion of the court. Kagan files a dissent in which Barrett and Sotomayor are joined. I don't understand, Rob.
Now, there's a part of this that makes sense and a part of it that doesn't. So Miranda was constitution derived. It's been known as a constitutional right, or it's a clarification of the Fifth Amendment right that you have. And actually, someone quite aptly in one of these other blogs and chats reference to Byron White's dissent in Miranda, the proposition that the privilege against self-incrimination forbids in custody interrogation without the warnings specified in the majority opinion and without a clear waiver of counsel has no significant support in the history of the privilege or the language. So basically, this is how we square it. Supreme Court comes out and lays out.
NYSRPA just dropped. I'm just waiting for the thing to load. We'll get there. We'll have to come back to this. We'll have to come back to this exciting whatever the hell this is on Miranda. All right, everyone. It's Second Amendment land. We are now going to speed read and speed understand the Second Amendment in 10 minutes less. No problem. We are just that good over here in Team Uncivil Law, Team Law and Lumber. Let's figure out what the law is on the Second Amendment, guys. Okay.
And we have our numbers, so this is the last opinion for the day.
And this is the last opinion of the day. Well, that's good. We don't also get Dobbs. That would just be too much from one day. Just one major Supreme Court decision. Well, I don't know. The Miranda one's pretty big because I have to figure out what the hell they just wrote. Anyways, the state of New York makes it a crime to possess a firearm without a license, whether inside or outside the home. An individual who wants to carry a firearm outside his home may obtain an unrestricted license to have and carry a concealed pistol or revolver if he can prove proper cause exists for doing so. An applicant satisfies the proper cause requirement only if he can demonstrate a special need for self-protection distinguishable from that of the general community. Petitioners Brandon Koch and Robert Nash are adult, law-abiding New York residents who both applied for unrestricted license to carry a handgun in public based on their generalized interest in self-defense. The state denied both their applications for unrestricted licenses, allegedly because Koch and Nash failed to satisfy the proper cause requirement. Petitioners then sued respondents, state officials who oversee the processing of licensing, for declaratory and injunctive relief, alleging that the respondents violated the Second and 14th Amendment by denying their unrestricted license applications for failure to demonstrate a unique special need. The district court dismissed the complaint and the Court of Appeals affirmed. Both courts rely on Second Circuit precedent decision in whatever, which held and sustained that New York's proper cause standard, holding the requirement was substantially related to achieving of an important governmental interest, which sounds suspiciously, incidentally, like a intermediate scrutiny analysis, which is not surprising because that's where all the courts of appeal are going to be. So what are we going to do? Are we going to expand the right to carry? Are we going to say it's strict scrutiny? Are we going to beat the Court of Appeals to a pulp? Let's find out. Held, New York proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms for self-defense. This sounds promising for the Second Amendment people. Let's not get too excited too fast, but, hey, the top line sounds nice. In District of Columbia versus Heller and McDonald versus Chicago, this court held the Second and 14th Amendments protect an individual right to keep and bear arms for self-defense. Under Heller, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And to justify a regulation must demonstrate the regulation is consistent with this nation's historical treatment of firearm regulation. Since Heller and McDonald, the courts of appeals have developed a two-step framework for analyzing the Second Amendment challenge. Well, really, it's a one-step framework because it's always an important governmental interest. So it's really one step, but whatever. This court rejects this two-part approach as having one step too many. Apologies, let me reread that. Since Heller and McDonald, the courts of appeals has developed a two-step framework for analyzing the Second Amendment challenges that combines history with means and scrutiny. The court rejects that two-part approach as having one step too many. Step one is broadly consistent with Heller, which demands a test rooted in the Second Amendment text as informed by history. But both Heller and McDonald do not support a second step that adopts a means and scrutiny in Second Amendment context. This sounds even more promising for the Second Amendment people. Further hope is elevated. Heller's methodology centered on the constitutional test and history. It did not invoke any means and test, such as strict or intermediate scrutiny, and expressly rejected any interest balancing test akin to intermediate scrutiny. Well, that sounds promising. It didn't adopt either strict or intermediate scrutiny, and also expressly rejected intermediate scrutiny. So what's left, right? Historical analysis.
It sounds like absolutist. I mean, I don't.
It sounds promising. It sounds promising, but I've had my hopes dashed many a time. I'm not celebrating to the end. All right. Historical analysis can sometimes be difficult and nuanced. Don't I know it because of arguing with people on my own channel about the Second Amendment. But reliance on history to inform the meaning of the text is more legitimate and more administratable than asking judges to make difficult empirical judgments about the costs and benefits of firearms restrictions, especially given lack of expertise in the field. That's for damn sure. Federal courts tasked with making difficult empirical judgments regarding firearm regulation under the banner of intermediate scrutiny often defer to the determination of legislatures. Yes, they do. While judicial deference to legislatures' interest balancing test is understandable and elsewhere appropriate, it is not deference the Constitution demands here. The Second Amendment is the very product of interest balancing test by the people. The Second Amendment is itself the interest balancing test. It's already been done, much like the First Amendment itself. You don't have to redo the interesting balancing analysis. It's been done for you 200 plus years ago. You're welcome. Great. The Second Amendment is the very product of the interesting balancing test and surely elevates above all their interests the right of law-abiding citizens to use arms for self-defense. The test the court sets forth in Heller and applies today requires courts to assess whether modern firearm regulations are consistent with the Second Amendment's text and history understanding. Of course, the regulatory challenges posed by firearms today are not always the same as those that preoccupied the founders in 1791 or in the Reconstruction generation in 1868. But the Constitution can and must apply to circumstances beyond those the founders specifically anticipated, even though the meaning is fixed according to understandings of who ratified it. Indeed, this court has recognized in Heller at least one way in which the Second Amendment historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century, which makes logical sense in the same way that freedom of press does not apply only to those methods of press that existed in the 18th century. To determine whether a firearm regulation is consistent with the Second Amendment, Heller and McDonald point towards at least two relevant metrics. First, whether the modern and historical regulations impose a comparable burden on the right of armed self-defense. And second, whether the regulation burden is comparably justified. Because an individual self-defense is the central component of the Second Amendment right, these two metrics are central considerations when engaging in the analogical inquiry. To be clear, even if a modern-day regulation is not a dead ringer, which is questionable phrasing in this decision, but whatever. To be clear, even if the modern-day regulation is not a dead ringer for historical precursors, which it often is not, see the First Amendment, it still may be analogous enough to pass constitutional muster, which is logical. Again, see the First Amendment. For example, courts can use analogies to long-standing laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, to determine whether modern regulations are constitutionally permissible. That said, respondents' attempt to characterize New York's proper cause requirement as a sensitive place law lacks merits because there are no historical bases for New York to effectively declare the island of Manhattan a sensitive place simply because it's crowded and protected generally by the New York Police Department. Suck it, New York. Suck it. You can't declare all of Manhattan to be a sensitive place. Whatever sensitive places means, it necessarily implies there is such a thing as a non-sensitive place. Otherwise, you don't need the adjective. To have one is necessarily to have the other. Yeah, okay. Having made the constitutional standard endorsed in Heller more explicit, the court adopts the standard to New York's proper cause. It is undisputed that petitioners Koch and Nash, two ordinary law-abiding adult citizens, are part of the people to whom the Second Amendment protects. Thanks for clarifying that, Supreme Court. That was nice. And no party disputes that handguns are weapons in common use today for self-defense. The court has little difficulty concluding. Also, the plain text of the Second Amendment protects Cox and Nash's proposed course of conduct, carrying handguns publicly for self-defense. Nothing in the Second Amendment text draws a home public distinction with respect to the right to keep and bear arms, and the definition of bear naturally encompasses public carry. That's powerful language I will take. Moreover, the Second Amendment guarantees an individual right to possess and carry weapons in case of confrontation, and confrontation can surely take place outside the home. The burden thus falls on respondents to show that New York's proper cause requirement is consistent with this nation's historical tradition of firearms regulation. To do so, respondents appeal to a variety of historical sources from late 1200s to early 1900s. But when it comes to interpreting the Constitution, not all history is created equal. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. The Second Amendment was adopted in 1791, the 14th in 1868. Historical evidence that long predates or postdates either time may not illuminate. Yeah, this is generally true, incidentally, in constitutional law analysis. The closer to the date of the constitutional provision, the more relevant it is. This is because this is the idea is that what they were writing is more informed by other things that are happening relatively contemporaneously, both before and after. So whatever they mean on date X, like on both sides of date X, the closer you are to date X, probably is more informative of what was going on in the general zeitgeist. So this is generally speaking true. This is right. Okay. With these principles in mind, the court concludes that respondents have failed to meet their burden to identify an American tradition justifying New York's proper cause requirement. Respondents' substantial reliance on English history and custom before the founding makes some sense, given Heller's statement. The Second Amendment codified a right inherited from our English ancestors. It sure does. It's the Second Amendment, the right to keep and bear arms, in which case we need to go start talking about a historical analysis. But this court finds the history ambiguous at best and sees little reason to find the founders would have thought it applicable in the New World. The court cannot conclude from the historical record that by the time of the founding, English law would have justified the right to publicly bear arms suitable for self-defense, only those that demonstrate some special need for protection. So there might be some history that indicates that, but certainly not enough, and certainly not enough in whatever context we're talking about. Fine. Respondents next direct the court to a history of the colonies and the early republic, but they identify only 3 restrictions on public carry at that time. While the court doubts that just these 3 colonial regulations could suffice to show a tradition of public carry regulation, even looking at those laws on those own terms, the court is not convinced they are the same. So yes, first of all, there's not very many of them, so it doesn't really speak to a wide understanding or a broad understanding, and even if they did, it doesn't help you in New York. The statutes essentially prohibit bearing arms in a way that spreads fear or terror among the people by including carrying of dangerous and unusual weapons. Whatever the likelihood that handguns were considered dangerous and unusual, which, no, today they are quintessential self-defense. So no, go away. Thus, the colonial laws provide no justification for laws restricting the public carrying of weapons that are unquestionably in common use today. Only after ratification of the Second Amendment in 1791 did public carry restrictions proliferate. Respondents heavily rely on these new restrictions, which generally fall into 3 categories: common law offenses, statutory prohibitions, and surety statutes. None of these restrictions impose a substantial burden on public carry analogous to what is here, which basically is a don't ever carry ever, we don't want it. Common law offenses. As during the colonial and founding periods, by the way, if you want to interrupt me at some point to talk, that's fine.
I'm trying to speed read ahead so I can see if I can add to discussion later.
Fine, that's very good. Common law offenses. As during the colonial and founding periods, the common law offenses of affray or going armed to terror the people continue to impose some limits on firearms carry in the antebellum, which is the pre-war period, pre-Civil War, incidentally. But there is no evidence indicating that these common law limitations impair the right to peaceably publicly carry. In the early to mid-19th century, some states began enacting laws that prescribed concealed carry of pistols and other small weapons, but the antebellum state court decisions upholding them advanced a consensus view that states could not altogether prohibit public carry of arms protected by a Second Amendment, which sounds suspiciously like you have to allow either open carry or concealed carry, dealerless choice. You can allow both, but you have to allow at least one. Surety statutes. In the mid-19th century, many jurisdictions began adopting laws that required certain individuals to post a bond before carrying a weapon in public. Contrary to respondents' position, these surety statutes in no way represent direct precursors to New York's proper cause requirement. So it might be the case, although we'll see if the Supreme Court's going to get there, it might be the case that New York may be able to require them to have some kind of insurance. But we'll see if the court's going to go that direction or not. While New York presumes that individuals who have no public right to carry without showing a high need, the surety statute presumes individuals have a right to carry that could be burned only if another could make out a specific showing of reasonable cause to fear injury or breach of the peace. Thus, unlike New York's regime, a showing of special need was required only after the individual was reasonably accused of intending to injure the other. Oh, so even in the surety statute, it wasn't generally applicable. It was only applicable to people who where there's some cause to believe that we might be scared of them. So it was only limitedly applicable. And even then, proving special need simply avoided the fee. In sum, the historical evidence from antebellum America does demonstrate the manner of public carry was subject to reasonable regulation. So again, open or concealed carry, dealer's choice. But none of these limitations on the right to bear operated from presenting law-abiding citizens with ordinary self-defense needs from carrying public in purpose for that purpose. The Ninth Circuit is going to be very, very sad, by the way. Hawaii is going to be very, very sad. Evidence from around this adoption of the 14th Amendment also does not support respondents' position. This discussed the right to keep and bear arms in Congress and public discourse as people debated whether and how to secure their rights for newly freed slaves. Generally demonstrates that during the Reconstruction, the right to keep and bear arms had limits that were consistent with the right of the public to peacefully assemble. The court acknowledges 2 Texas cases that approved a statutory reasonable ground standard for public carry analogous to New York's. But those decisions were outliers and therefore provide little insight into how postbellum courts viewed the right to keep and bear arms. Finally, respondents point to a slight uptick in gun regulation during the late 19th century. As the court has suggested in Heller, however, the late 19th century evidence cannot provide much insight into the meaning of the Second Amendment when it contradicts earlier evidence. In addition, the vast majority of statutes that respondents invoke come from Western territories. The bare existence of these localized restrictions cannot overcome the overwhelming evidence of an otherwise enduring American tradition that permits public carry. Moreover, there's territorial laws were rarely subject to judicial scrutiny, and absent any evidence explaining why these unprecedented prohibitions on all public carry were understood to comport with the Second Amendment, they do little to inform the origins and continuing significance of the Second Amendment. Finally, these territorial restrictions deserve little weight because they were, consistent with the territorial nature of a territorial government, short-lived. Some were held unconstitutional shortly after passage, and others did not survive once they became states. After reviewing the Anglo-American history of public carry, the court concludes the respondents have not met their burden to identify an American tradition justifying New York's proper cause requirement. Apart from a few late 19th century outlier jurisdictions, American governments simply have not broadly prohibited the public carry of commonly used firearms for personal defense, nor have they generally required law-abiding reasonable citizens to demonstrate a special need for self-protection distinguishable from that of the general community. The constitutional right to keep and bear arms in public for self-defense is not a second-class right subject to entire body of rules than other Bill of Rights guarantees. The exercise of all other constitutional rights does not require individuals to demonstrate some special need. The Second Amendment right to keep and bear arms is no different. New York's proper cause requirement violates the 14th Amendment by preventing law-abiding Americans with ordinary self-defense needs from exercising the right to keep and bear arms in the opinion. Thomas delivers the opinion of the court, in which Roberts, Alito, Gorsuch, Kavanaugh, and Barrett join. Alito files a concurring opinion. Kavanaugh files a concurring opinion, which Roberts joins. Barrett files a concurring opinion. Breyer files a dissent, in which Sotomayor and Kagan join. Okay, so let me translate all that for you and what it does mean and what it doesn't mean, at least for the foreseeable future going forward, at least in my humble opinion. Unless Robert wants to start with it, because I've been talking for a little while now.
So just mentioning briefly here, Breyer's dissent. So first of all, this opinion by Thomas goes for 63 pages. So we're going to be analyzing this for a little while. Breyer writes a lengthy dissent, apparently references to Buffalo, Uvalde, and a lot of news stories about the shooting. And Alito does his concurring opinion does nothing except add commentary directly to the assent. It's a clapback. It basically says, this is what we're doing today, which I think is a really concise statement of this. Basically, our holding decides nothing about who may lawfully possess a firearm or the requirements that must be met to buy a gun, nor does it decide anything about the kinds of weapons that people may possess, nor have we disturbed anything that we said in Heller or McDonald v. Chicago about restrictions that may be imposed on possession or carrying of guns. Basically, it just says that you can't pass a law of this type. Mm-hmm. And reading beyond that, reading to some broader understanding, takes these types of orders and rulings well outside the scope of what it's intended to do. This is essentially articulating what a right is and a right isn't. You need to read this opinion. Anyone who's doubting this opinion or the veracity of this opinion, read this opinion and replace gun with speech. Just replace gun with speech, because that is what this court is doing. And that's why I'm happy with an opinion like this, because I'm not so concerned on the Second Amendment part, but I'm concerned with what other states have done towards regulation of free speech and freedom of the press.
Right. Yeah. Very, very good. Yeah, we will definitely be reading this in more detail. We will definitely have a breakdown on my channel in more detail. I'm not sure when that will occur necessarily. Maybe Nate will be kind and let me borrow his laptop or something so I can stream, because I'm not really set up for that when I'm visiting VidCon. I can do it because I don't have the text in front of me. But we'll try to do this at some point in the near future as time allows. Here's what I understand the court to be saying and what I understand them not to be saying. All right. So what I understand them to be saying is, first of all, you have a right to carry. The method of carry is still open to the states and can be reasonably regulated. And so broadly speaking, that would say the states have to choose between open carry and concealed carry. But even then, within those choices, they might be able to choose specific methodologies. So it might be possible, for example, for a state to say, and I'm not saying that they can do this, I'm just saying that they might be able to do this. Like, yes, you can conceal carry, but you can't conceal carry by having a firearm in your pocket. It has to be in a holster. It has to be, it has to be done in specifically these ways. It can't print. It can't do this, or whatever. So, but you have to allow people of ordinary lawful people to carry, whether it's open carry or concealed carry. You can have both, but you have to have at least some method of carry that's available to members of the general public. Generally speaking, that license to carry extends in non-sensitive places, the general world, most of the island in Manhattan. The various places, and New York had a bill proposed, and I don't know whether or not it went to law or not, but they had a proposal to try to basically take it away from everywhere that they could think of. It excluded, the proposed legislation would exclude a person carrying on a subway, on a train, within a taxi, within an Uber, within like any place where like 15 or more people are gathered or something or whatever, right? So basically trying to exclude everything. It would allow you to carry on streets probably, but probably not like within any kind of business or any confines, which of course then, like, what are you supposed to do? Because if you're carrying on the street and you can't enter anywhere, then you have to leave it at home. So the state of New York was proposing this idea. They might, the degree to which they can or cannot do that is still a bit open. Now, what the Supreme Court is telling the lower courts to do is look at things that are similar to the sense of places we've enumerated, such as schools, for example. But what the courts of appeal are more likely to do than not, given the history of the way the courts of appeals have been looking at this, is try to declare all the places to be sensitive. That's the next logical place for the courts to go, the lower courts, because they've shown disdain for the Second Amendment. So it's like, yes, you have a right to carry in the general, but you don't have a right to carry in the sensitive places, and all the places are now, we're going to try to expand them as wide as possible. So you can reasonably anticipate going forward that legislation similar to New York's legislation, whether it's become law or not, will become law in various jurisdictions. They will try to declare as many places to be sensitive as possible so that the right is so burdened that it becomes impractical. Also, incidentally, Hawaii had a proposal, and I don't remember if this has become law or not, but would require you to do training, I think, every year, possibly twice a year. The proposed legislation also would require a person who's carrying to also carry a taser, and I believe also get insurance, and also some other things was Hawaii's proposal. I don't remember if that became law or not, but again,
I mean, why go that far? Like, why go that? Like, I get a lot of this common sense stuff. So basically, if you sum it up, Heller was outlawing the rule in place was basically no guns even in the home. Period. End of story. Supreme Court said nope. Saying no guns in the home, too massive. Strike down. Fundamental right. This case, New York's law basically said if you are outside of your home, any place outside of the home within the city limits, all of that space is a protected space. Supreme Court here says, nope, still too broad. And then it goes on and says, if you're going to define some restriction, some method, there are still these safe places that are small and constrained, but we're also not saying you can't require insurance. We're not saying you can't require some methodology. Now, Hawaii going and doing what they're doing, why do you have to go off the rails like that? Why don't you try something?
Well, I mean, I think you kind of answer your own question a little bit. I mean, the answer is in the question. Why Hawaii? I mean, Hawaii is the answer to the question, right? It's right there. Because these states hate concealed carry. They hate firearms, and they're going to push it as far as they have. I mean, they're already pushed. I mean, that's a little bit like asking why try to ban carry on the entire island of Manhattan. I mean, obviously, it seems obvious to me that there are jurisdictions who are going to try to push this in every possible way, because why not? The courts of appeal are unlikely to stop them. Hawaii, which is a member of the Ninth Circuit for sure as hell is not going to stop them. The Ninth Circuit has never found, ever, once, ultimately, a gun regulation they don't like. Sometimes on panel decisions, but every single time they've overruled themselves on bonk decisions. In fact, there was a judge, we read that decision from the judge, who wrote basically his own dissent, because I'm just going to save you time, because here's what I think, but since the Ninth Circuit's going to overrule me anyway, I'm just going to go ahead and write the dissenting opinion, so you can just, carbon copy that and copy paste. It was pretty hilarious reading it, by the way, incidentally, based judge for sure. But yeah, I mean, these jurisdictions are going to try to push it as far as they can. The Ninth Circuit's going to let them get away with everything that they can. So yes, they're going to have to issue concealed carry permits, but they're going to try to make it as difficult as possible. The language here suggests they can't have a surety bond unless they show some special need. Maybe that's in the opinion more generally that we can find language, but when we analyze it more, we'll get more into that. But absent that being more rooted here, then they're going to require people to get insurance. They're going to require people to get training. They're going to require people to get recertified and pay costs. They're going to require them to do, they're going to try to do the hokey pokey, as it were. We're going to try to make it as burdensome as possible. And then even when they get the license, we're going to try to exclude them from carrying as many places as possible, so that carrying becomes impractical. Why wouldn't they? They're going to absolutely do that. I mean, you can see the future, and you can see the courts of appeal, which have shown such disdain, upholding much of this under intermediate scrutiny, or if they don't like that because they're not allowed to do that anymore, although they'll certainly try, they'll just say it's a historical analog because, I don't know, some tavern in Boston in 1783 banned carry, so we can ban them in all the taverns, carbon copy paste, etc. I mean, where the future is going. It's not that hard to predict because you know where the past has been.
Yeah, it's not. And Breyer leads in there. So Breyer's dissent gives a nine-page introduction. Okay, 9-page introduction of statistics and all of this other stuff. And it's just, one, I'm kind of glad Breyer wrote it and not Sotomayor. I can only imagine what a Sotomayor dissent on this particular issue would read like. Breyer writes it, so at least you have some scaled back version of the rhetoric, but it's still rhetoric, and it's going to be cannon fodder. It's going to give all of the anti-gun or anti-Second Amendment or anti-First Amendment lobby a ton of things to talk about. Scary things bad, scary words bad, scary guns bad. It just propagates further attacks on rights that are just there. It drives me crazy.
Well, I mean, so the Supreme Court, at least for the moment, what you do have is you have a right to carry in public that cannot be premised on showing a special need. What else it can be premised on, though, becomes the thing. And we require you to go to a shooting range, 8 times a month, even though there are no shooting ranges nearby. We require you to get this certification. They have to be our certified people, and there's only 2 of them. So good luck getting a class from one of them. We require you to pay these fees. We require you to get these bonds. Oh, it's $1 million bond because you could cause a lot of damage with a firearm. $10 million bond because you could cause a lot of damage, $100 million bond because you could cause a lot of damage. I mean, you can only carry these caliber of firearms. Can't carry anything above 22 because that's just too dangerous. 22 should be enough to protect yourself. I mean, if you need me to red team this and just start writing gun restriction legislation that will comport with this decision, I can try, because I can take this to its outer limits, and I'm sure the legislatures will have no problem doing the same thing.
It's not hard. It's honestly not hard. They left a pretty open door. I mean,
yeah. I mean, it will basically be I can write mock legislation. It'll basically be me giving the middle finger to the Supreme Court. But what else is new?
And Kurt, to your point, it would be a really interesting exercise to see how far you could draft that legislation, then put it to a challenge. Like, draft legislation, then I'll read this opinion. We'll do a deep dive on the opinion and say, would this legislation pass muster under this?
Yeah.
I don't think the 2A lobby would like you very much for doing that, though.
You don't think they would appreciate the academic exercise of me starting to draft really gun control legislation? Wait, Kurt must really believe this stuff. No one who doesn't believe this stuff could write legislation that good.
It's just to prove a point to the people that are just like, the Supreme Court just said that you can't regulate guns. No,
it's like watch me.
Yeah,
watch me, right? It's like, oh, you don't think I can regulate guns? Watch me. I'll regulate guns. I'll regulate them so hard you won't even know what happened by the time I'm done.
I mean, the worst is, and this is something that's really important about this one. We just did a 10-minute speed read, but I guarantee you that probably every single attorney on LawTube, every single attorney that has the opportunity to break this opinion down and give the actual common sense bullet points of what it actually means, please do it, because I can guarantee you that the public media networks are going to botch the hell out of it.
Yeah, no. Well, I think the news networks are probably more likely to go with the scare and doom, because that's probably more profitable. I think probably the more likely headlines from our friends in mainstream media will be, Supreme Court authorizes everyone to have a gun. Everyone can carry now. Your gun in your bar, it's more likely than you think. Film at 11. So I can write the news people. It's great. I can go ahead and write the news pieces and the hot takes on the Vox, and I can write it in that style. And then when I'm done, I can write some legislation that will completely obliterate the right to bear arms, that we will pass constitutional muster, and I can just black hat this all and just save ourselves a lot of time.
Is the chat right? Is it Justice Thomas's birthday and he writes this opinion?
That's what they're saying.
That's got to be public info, right?
Oh yeah. And then Riley says, then find my exact words in a new bill. I'm sure. Even a Second Amendment supporter, Uncivil Law, says that this legislation would pass muster. No, wait, that wasn't what I meant.
Yeah, it's Justice Thomas's birthday.
All right. Jim says, you guys sound black-pilled. It says the history at signing is the only test. That means there are a ton of unconstitutional laws in the book. Oh, you sweet summer child. I'm black-pilled because I've had the misfortune of reading courts of appeal decisions since McDonald, which is now what, 10 years old, 9 years old?
Mm-hmm.
Yeah. And so I've had the misfortune of reading many courts of appeal decisions. So I don't know if I'm exactly black-pilled as I am. I know what the case law says, and I know from the case law and from the way the courts write their decision what their overall temperament is. So I kind of have I have an informed posture of what I think the courts of appeals are likely to do going forward. So I don't know if that's black-pilled or not, but you don't have to be that black-pilled. I mean, the Supreme Court did just take 10 years to hear a Second Amendment case. They hear 3 or 4 First Amendment cases every single year. Well,
and this particular case has been dismissed out for mootness how many times?
Yep, that too.
Like this has come up in how many terms? And as it comes up, it's not ripe. It's moot because New York legislature goes back and revises and tweaks the rule and tweaks the rule and tweaks the rule.
Yeah. So yeah, how black pill do I have to be? It's like, well, the Supreme Court obviously doesn't like hearing these cases because they haven't heard one in 10 years, unlike the First Amendment where they hear cases every year. So the Supreme Court's not going to do jack shit about it. Okay, so so now I'm down one level lower. All right, so what does it look like in the Ninth Circuit? What does the case law look like in the Third Circuit? What does the case law look like in the First Circuit? In this, by the way, for those of you who are not cognizant of such things, this includes states like California and Hawaii and Massachusetts and Maine, New England. It's like, what is the case law, Fourth Circuit even, from Virginia and Maryland, because they're Fourth Circuit law that I'm aware of. So it's okay, like, all right, so since the Supreme Court's obviously not going to do anything about anything, right? What is the First, Fourth, Third, Ninth Circuit likely to do based on my understanding of the case law up to this point? How far can I push it? And then I start writing legislation in my head. I'm like, well, I can push it pretty hard because I know where these courts of appeal are likely to go. And the U.S. Supreme Court isn't going to stop me. So yay. It's just being realistic, right?
I mean, yeah. And the thing is, what the chat might not realize is the two most significant cases on this, Heller was 2008, McDonald 2010. It's been 12 years.
Yep.
12 years where states and circuits have been splitting and ruling in just. This has been a decision that has been long since coming. So hopefully this statement at the end of the day is a clearer statement, because it's not going to be the most clear in the world.
Yeah, right. So since I'm bringing it up, I might as well show you a map to show you what I'm talking about. This is what we talk about when we talk about circuits, also known as courts of appeal. They're the same thing. So when you hear me mention a circuit court, it's the same thing as a court of appeals and vice versa. And it's geographically based. So these are like, okay, so I'm thinking about these circuits because I'm thinking about decisions I know from these cases. So like Ninth Circuit, Alaska, Hawaii, Arizona, California, Nevada, Oregon, Washington, Idaho, Montana. The Ninth Circuit Court of Appeals is the highest court for that region. Before you get to the U.S. Supreme Court, that's where the buck stops for the Ninth Circuit. First Circuit Court of Appeals, Maine, New Hampshire, Massachusetts, Rhode Island. Second Circuit, New York, Connecticut. Third Circuit, Pennsylvania, New Jersey, Delaware. Fourth Circuit, West Virginia, North Carolina, South Carolina. So first, second, third, fourth, ninth. And I know like the decisions that tend to come out of these regions when it comes to gun rights. The Ninth Circuit literally has never struck down a gun regulation ever. Nope. Sometimes their panels have, but en banc, they always overrule themselves. The Ninth Circuit has never found a gun regulation they don't like. So when I'm thinking about what legislation can I get away with, well, pretty much anything. And some of these decisions from first, second, third, fourth are not much better. So when I'm thinking about legislation that can pass muster, this is the kind of thing I'm thinking about. Not to say that the Fifth Circuit is probably the best right now for the gun rights, to be quite honest. I'm not super familiar with 10th Circuit case law on gun rights. Do you know much about the 10th Circuit gun rights?
Well, no, not really. But what I can say about the Ninth is I can guarantee the Ninth Circuit's probably already drafting opinions on how to get around this one. Whatever this opinion says, the Ninth Circuit's going to try and distinguish the hell out of it.
I think there are 23 judges of the Ninth Circuit. And so there's 23 judges who are very, very smart people already dreaming of ways to overrule, without overruling what we just read. So this is like, what can we get away with? So if I'm thinking about legislation in the Ninth Circuit, I'm thinking about Hawaii in particular and California. California and Hawaii are going to be my drivers for the most infringing legislation when it comes to the Second Amendment. I know this from history. Washington to some degree, but even Washington is more tolerant than California and Hawaii. California and Hawaii are going to be the ones that are going to push it to the absolute limits. And it's like, well, was the Ninth Circuit going to reverse? Nothing. So, okay. So, yeah. This also, incidentally, for what it's worth, absolutely does not require them, at least at the moment, to honor concealed carry permits from any other jurisdiction or open carry permits or whatever kind of permits they're going to give. So New York could still have separate permits for New York City. There's nothing that precludes that because that's the law right now in New York. You need a special permit just for New York City on top of New York State. So there's nothing that precludes that. And there's nothing that requires them to honor a permit from any other place. So if you want to carry in New York City, I'm going to just tell you, you're going to have to get a special permit, and they're going to make it as hard as possible, and they're going to ban you from carrying it everywhere. They're going to say, if they haven't already, that you can't carry in the subway or on a train or in a car in a taxi or in an Uber, and you can't carry it into any business which has more than X people, or any place that sells or serves alcohol, or near any school zone, or near any whatever. And so good luck actually complying with all that. They're going to make it as difficult as possible. Yeah. And they're going to require you to inform the police, who are then going to harass the shit out of you, and so forth and so on. So, yep, that is our dark future for the immediate moment, because the Supreme Court isn't there. Maybe with Justice Barrett, maybe this is a sign. The only hope you have at this point, really, the only hope you have is that Justice Barrett being there is some indication that the Supreme Court might be more willing to take cases going forward. Because Judge Jackson replacing Judge Breyer doesn't change the calculus. You know, you still got Barrett, Thomas, Alito, Kavanaugh, and Gorsuch, and maybe Roberts, depending on the day. So you got at least 5 votes. You only need 4, incidentally, to hear a case. It's a rule of 4. You need 4 to agree to hear a case, but you got 5 now. So your only hope is that you think that this is an indication going forward the Supreme Court might be more likely to take up positions. But I'll tell you what, if I'm a legislature and or a court of appeals, I'm not going to bank on that. I'm going to bank on the opposite of them just being cowards, because that's more predictive, and wait for them to slap me down, and then I'll see what I can get away with next.
So we only had 4 opinions released today. They have another opinion session scheduled for tomorrow.
Yep. Yeah.
So we've got 9 left.
Yeah. They're not going to release 9 tomorrow. They're going to release half of them, and then half of them next Tuesday or next Monday.
I'm just thinking,
or on the 30th.
This opinion, you wait for these opinions, you read them, and I'm waiting for them because I want to see what the decision is. But now that the opinion's out, my fear immediately goes to, well, not fear. It's like, now we're going to have to listen to the media spin this. The Supreme Court, the media is going to probably predict doom and gloom about, the new Wild West. I mean, you can just write the Voxen articles yourselves. The new Wild West, how Supreme Court endangers us all. Just call me Taylor Lorenz, and I'll start writing it for the Washington Post. I'm never calling you Taylor Lorenz. I have too much respect for you.
I appreciate that. Thank you. Yeah.
What a nightmare. If I'm the Supreme Court, by the way, I'm releasing Dobbs tomorrow, Friday.
That'd be gangsta.
I mean, you release it going into a weekend, so you don't have to come back and reconvene the next day, or it's the last day and you adjourn. But
you try to squeeze out every opinion tomorrow. That'd be hilarious.
Oh, overload everybody.
That'd be good. Just drop Dobbs in a huge day, along with the Biden decision and also the Oklahoma decision. So you got the Biden decision, which is still major. You got the Oklahoma decision, which is still major because we may be reconsidering the idea of tribal land and half of Oklahoma not being in Oklahoma anymore. We might want to reconsider that. So the Oklahoma decision is major. The Biden decision is major. And the Dobbs decision is major. So you got 3 major decisions, at least by my count, still to come out.
Yep. And to the chat, I saw that Kathy Hochul released a comment. She's not trying to circumnavigate the opinion. She is doing exactly what Kurt just said. She is basically looking to different ways that she can tailor the law that is consistent with this opinion, but offers restrictions that are here. It's not circumventing. It's just taking the letter of the law and then
pushing it to one step down. Push it to the limit. 1980 style. Push it to the limit. Yeah. Life is on the range's edge. Don't look back until you get it. Yeah. So good times. I'm going to try to be on tomorrow as well. I'll be mobile, so we won't have probably the text on screen tomorrow morning. But I'm going to be on and from my phone, and we can try to do this again.
I'll be mid-flight, unfortunately.
Okay. Well, it'll just be me at 7 a.m. yelling into my phone. I bought MV88 Shure mic to try to improve the audio quality on my phone. We'll see how well that works. Yeah. Kurt is the Twitter sphere is yelling doom and gloom, and we're all going to be shot. Yeah, I mean I mean, yeah, that's what they're going to be trying to sell. Should I just go ahead and tell you what Chuck Schumer is going to say? Because I can tell you what he's going to say because it's not that hard to predict. Should I just do my best Chuck Schumer impression? Because he's
just don't try to mock the accent. Like the accent that'll kill me. I need to make it through the day. But yes, do your Chuck Schumer impression.
It's like, this morning, the Supreme Court issued its decision that radically presents new threats by putting guns in the hands of crazed criminals within the streets of New York. This irresponsible decision by this conservative Supreme Court creates an ongoing threat of gun violence in the immediate aftermath of situations like Uvalde. The Supreme Court has shown disrespect to the choices of the citizens of New York by putting guns in those who, on a moment's notice, with no background check whatsoever, will be able to pull out a gun on the streets of New York and lay waste to our citizens. How am I doing so far?
Pretty good. I would have added the Supreme Court. That was terrible. What was that accent that I was trying to do? It was awful. Supreme Court themselves have become a weapon.
Mm-hmm.
They are themselves a weapon used in schools, weaponized against children, against the public, against everything. The Supreme Court is dangerous. Weapons. Danger.
Yes. And these weapons will soon be in our city parks, inside Central Park, where tourists go. There will be a gun on every picnic blanket.
Oh my gosh.
And now when someone doesn't get their mustard on their hot dog, it will result in gunfire. I mean, that's your general theme for Chuck Schumer. I like the Supreme Court as a weapon, though. This horrible decision from Justice Thomas.
Yep. Someone said something more like Biden. Yeah, I can see Biden doing that as well.
No,
I can see anybody saying that.
The Biden is going to be more like, oh, geez, can I do a Biden? This is going to be hard. Biden's going to be like,
jibbity jabba.
That's the problem. Our Supreme Court issued a decision today on the issue of the thing, and this presents a problem for America. As our economy continues to tank from this decision, I pooped my pants. Come on, man. Yeah, that's more Biden speed. Yeah. At good times. Yeah. Also, I also forgot this aspect of Biden. This is a good point. Yeah. The Supreme Court said that what matters is the historical analog, and what this means is that soon people will be having cannons, and people will own cannons in the streets of New York, and soon gunfire will be replaced by cannon fire, because no one needs an AR-47. These reprehensible weapons of war, assault weapons ban, pirate ships, something, the aristocrats.
I mean, he realizes that the argument is closer to the Second Amendment permitting those types of weapons than permitting handguns. The purpose of the Second Amendment to basically make sure that your government can't.
Yeah. We must pack the courts. Yeah, that might pop in. We need Supreme Court reform. Yeah, I could definitely see that too. Garrett Jackson said, "Happy birthday to Justice Thomas. God bless the Second Amendment." Takina Meyer said, "I'm confused. On the first case, did they uphold the voter ID law?"
They didn't touch the merits.
They didn't touch the merits of it. Yeah,
they went to the intervention.
Right. Ellie Phoenix says, "I think the individual requesting different method of execution could bring significant weight. He did not say I'm innocent or someone messed up. It's very specifically, I want to die by another method." Well, that's what the law requires him to do. He's required to do that.
Yeah.
Brett Comer says, "Would they start outsourcing execution in Texas and then say it become a business? Because Texas won't do it for free. Come to Gary's Import. We got all your methods of execution.
Oh, Brett.
Hanging, electric chair, gunfire, and even more esoteric methods like sharks with laser beams. Whatever you need, Gary's Emporium, located off of Interstate 90.
Execution by sharks with laser beams.
Yeah, that's right. Just Me says, okay, let's do some reading. Let's roll. Jeff says, my understanding was the surety bonds were so felons could carry. Maybe,
Yep.
but that will in no way prevent the states from regulating it more unless the law doesn't allow for it. I will be reading this opinion in full on my plane flight. And then when I land, maybe in the car, I will do a vlog, and that'll be fun. And Stephanie says, give me 5 minutes and access to the New York police database. I can find 24 cases involving drive-by. No mustard on a hot dog. Bet. I know. That's what I'm saying, man. It's easy, right? It writes itself. Your 10th execution.
Oh, that is. Oh, gosh. Oh, gosh.
We're all going to hell.
No, it's we're not finding humor in sad things. We're actually just expounding upon logic and taking them to their most insane conclusions. It is funny to think that, though. Oh my God.
50 Hong Kong dollars. Hello. First time joining Super Chat. Hello from Hong Kong. Hi, Rob. I'm a fan. You've got fans in Hong Kong, Rob. Yeah.
Well, you stream at all times. The thing is, I find that when you stream at all different times of day,
Yeah.
you hit people at all different times. I did a live stream on Lindbergh last night.
Uh-huh.
And at the very end of it, someone was like, waking up in Abu Dhabi. I was like, holy crap. That's awesome.
Yeah. So yeah, I will be covering this decision at some point more today. Probably solo, probably me in a car. It'll be hilarious. But I think that'll bring us to the end. Law and Lumber, what you got coming up on your channel?
I have not thought that far ahead. My brain
Okay,
hurts.
great.
I'm reading this opinion.
Well, that's a good place to start. Yeah, read this opinion and try to explain it to us, and then I'll try to explain it to us, and we'll see how close we came. That'll be fun.
Sounds good.
All right. Well, don't forget to check out my friend Law and Lumber on his channel, and like, comment, subscribe on this channel as well. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers and goodbye.